Sheila Rule, moderator of the In Our Name conference. On a beautiful August weekend, an array of advocates, professionals, and the general public came together to discuss the state of our criminal justice system. What you're about to experience is a compelling mix of thoughts, ideas, and stories that will help us all to reframe our thinking about crime and violence in America so that we can move forward toward a just and fair system for all.
Good morning. Good morning. All right. I'm going to start just introducing a little bit about myself beyond what Sheila said. Steve is going to introduce himself, talk a little bit about that, and then about public defense, the condition it's in, and the lawsuit, Hurrell Herring, that is sort of the topic here. We want this to be a conversation, and while we understand that it's being recorded, broadcast, and so on, we're going to try not having you go to the mic because we want things to move along, and so we will repeat questions or comments as we go. If that starts not working, we'll have to go back to the mic. So we will try to speak slowly and clearly. We hope that people with questions and answers will do the same, and we'll see how it goes. As the little flyer that I put, handout that I put on some of on the tables says, I'm here both because of what's in my head and what's in my heart. I went to law school. I got a job at the State Appellate Defender Office in Michigan, and I thought, I want to do appeals because I like the thinking process of the law. I really wasn't terribly sure about my ability to interact well with people, and I knew that I loved research and writing, so appellate law, doing appeals, seemed like a good idea, and it was a great job. I have to stop and tell you a story that I hadn't planned to tell, but Reverend Lewis's comments just brought this to mind. I had a colleague there, light-skinned African-American man, quite a bit younger than I am, and he and I were chatting one day in the office library about race. And one of the other attorneys came in, white attorney, and whatever Jordan was saying at the time, she said, "Oh, you're too young to remember that," meaning Jim Crow. And Jordan told her a story, and I won't tell you the whole story because it was quite detailed, but it had to do with going south to visit relatives and asking ahead of time, where is it safe, and using the side of the road. And when he'd finished telling the story, I believe that my colleague understood that despite the Civil War ending slavery, and despite the Civil Rights Movement having ended the legal part of Jim Crow, the laws that said you black person can't go here, you white person can't help a black person go there, the law had been wiped out, but by no means had we achieved equality. And I carried that with me. I went to the National Legal Aid and Defender Association to get an idea of were these problems with public defense and injustice more than just what I saw in Michigan. Personal travels and so on eventually brought me to New York, and at the New York State Defenders Association we try to help fix the problems in public defense. We'll be talking about that. So what's in my head are legal principles. Sometimes I fall into legalese. Call me on it. What? Say that in English. But also in my heart, I found out by doing appeals for people who had been convicted of crime, most of them rightly as opposed to wrongly in terms of their having done something that was criminal, maybe not as severe as what they were convicted of. And I thought, as I left, said, this was a good run, and we made some good law. That was when you could still make good law. And I discovered after about 2 years of being gone that I couldn't remember the legal issues that we had made, by and large. I remembered the people. I wonder what happened to Lawrence. I feel bad for Peaches, who's doing life without parole, for being involved in a very bad situation, but she came from a very bad situation. And I don't remember at all what the issues were that we raised for her. So when I read Michelle Alexander's book, The New Jim Crow, Mass Incarceration in the Age of Colorblindness, I was very struck by some of the things she said, and one of them was the law case, the Supreme Court case in Brown versus Board of Education, did not end Jim Crow. A mass movement had to emerge first, one that aimed to create a new public consensus opposed to the evils of Jim Crow. And so my position, my office supports, we did not bring the Hurrell Herring lawsuit, but we support the idea and improvement in public defense. But we understand, I understand, and I think you understand that the lawsuit alone is not going to fix things. It's going to take people saying, we want real justice in our county for the people who are accused of crime by our county authorities. It's going to take people saying, as Michelle Alexander did, we have to learn to love people, and that includes people who've been pressed into the caste of felon. It's a racial caste, but it's also a broader caste, and we're not going to fix that until we all speak up, as Reverend Lewis said. So while we're going to talk a lot about the case, and Steve will start with that, I'm also going to be mentioning things like the New York State Prisoner Justice Network, which is a sort of umbrella group with people working, organizations working along the whole justice, criminal justice or injustice spectrum, from people at risk of becoming incarcerated or going into the system, people at the point when it can make a difference, public defense, that initial charge, people in prison, the conditions there, people coming out, the whole range. And the idea of the Prisoner Justice Network is that we're busy working, each of us in our ministries, in prison, in reentry groups, wherever we're working, with that cause. But if we take a little time to join together and do a little work together, support each other, our constituency is much broader. And the New York State Defenders Justice Fund, which is the, well, if we had any grant money left, we'd be the lobbying arm for the New York State Defenders Association. We want justice, and racial equality is one of the major tenets of the New York State Defenders Justice Fund. It's a member of the Prisoner Justice Network. So all of those hats that I wear, I assume that many of you wear even more hats and work twice as hard, and I hope that we'll have a conversation about all of those things and how they fit in to the problems in public defense, the injustices that occur every day in every county in the state, some more than others, but everywhere. And Steve is going to start us off with that after he introduces himself.
Hi, thank you for being here. I was delighted that we started off today with a discussion about the new Jim Crow, because that leads perfectly into why we are here discussing the inadequacy of criminal defense. You know, the new Jim Crow, in order to maintain that, it absolutely depends on the fact that the targets of that are not heard. They have to be silenced. And the corollary to that is that they can't have legal representation that is going to raise their issues. So somehow we have to make sure that the lawyers don't have an opportunity to speak for them either. And so I suggest that while New York State has an extremely dysfunctional legal system to represent the poor, there is a reason for it. The reason may not be clearly articulated, it may not clearly be understood even by the people that are putting it in there, but there is a reason for it, and we can understand that reason if we look at Michelle Alexander's analysis. And I would suggest that although New York has a uniquely dysfunctional system, which I'm going to describe in a minute, virtually every other state also has a dysfunctional system in different ways, because each state has worked out in its own way how much voice they want to give to the poor, to the marginalized, to the people that we want to treat as the new Jim Crow. This is what it is all about, and this is why consistently, continually, over time, you will not find very good functioning legal systems, because once they start to speak for the poor, they will find a way to make it difficult to silence them. So I will just start with that premise, and I will refer to it from time to time as I go along. I'm going to focus on the New York State system, and clearly we have to do something to fix that. But it is such an unusual system in a way that it's not duplicated elsewhere, and I don't want anybody to be confused that somehow fixing New York State is going to fix what goes on in the rest of the country. We also have to fix that as well. I started out in 1978 coming up to Albany as the chief attorney for the Commission on Judicial Conduct, investigating bad judges. And I realized that for my section of the country, which was the top third of New York State, out to Syracuse and down to the middle of Hudson Valley and up to the Canadian border, in that area, the Commission was basically the only real oversight body for the court system. There is, of course, an Office of Court Administration, but they did not have as much probably day-to-day contact with the courts as we did, which I will explain in a minute. But I also understood, or slowly began to understand, that we were also probably the chief oversight for the public defense there, simply for the same reason that there was no real competent body that went out there and on a day-to-day basis tried to decide what was going on in the courts. And in order to explain why this was the case, why the Commission on Judicial Conduct would end up with this kind of a role, I need to tell you a little bit about the court system. New York State, when Gideon against Wainwright, it came down in 1963, each state was required to set up a system of public defense. And in New York State, it has 62 counties, and it was decided, for one reason or another, that the best system would be to allow each county to set up a public defense system. They were given three choices. They could either do a public defender, a legal aid group could take over the public defense, or you could have an assigned counsel system. But each one could set up their own system and run it for their own expense. And using Michelle Alexander's analysis again, I would suggest that the reason for that was because in our very diverse state, going all the way from Hamilton County up north with a year-round population of maybe 2,000 people, down to New York City, another county, New York County, with a vast number of very sophisticated people, it was hard to decide exactly how much voice we wanted to give to the poor. Each area might have a different ideas to exactly how much they wanted the poor heard. And so the idea would be, fine, let's everybody set up their own system, and then they can regulate exactly how much the poor get heard. And so right from the very beginning, we started out with a system that was completely fractured. There was no real consistency throughout the entire system. And I'll just give you two quick examples. One was from a public defender, one from a assigned counsel program, to show you what that was like. We got a complaint at one point that a judge was calling in people that were represented by the public defender without the public defender being present and telling them they had to plead guilty, and was taking the guilty plea, so people were upset about it. I think it was actually the public defender that sent in the complaint. And so we brought the judges in to find out why this was going on, and it turned out that the public defender was a part-time public defender. This was a very, very small county. It was very poor. They only had one person was assigned to do all of the public defense, and he was part-time. And it happened that one of the clerks to the judge had murdered his wife, and it was the first time that in 20 years that they'd had a murder case up there, and somehow the public defender was representing this guy. And it was a 6-week trial. And so the public defender had simply sent out a notice to all the courts that he was tied up in a trial. He was unavailable to go to any of the other courts, and so he couldn't handle any of his other 100 cases. Now, some of these people were sitting in jail, and they had now been in jail longer than the maximum sentence for which they could be sentenced. They were sitting in there awaiting trial, and they were already there too long. So the judge said, my God, if I keep leaving them there for another 6 weeks, they will have served 2 whole sentences. I've got to bring them in, but how do I get them out of jail? I have no way to get them out of jail except if they plead guilty. Then I can set them out. So that's why he was doing it. Now, this is just one bizarre example, and everybody's like, what? This is how the system works? In fact, this was not uncommon, and I think we just looked at it and said, okay, this is just the way it goes, and we dismissed it because it wasn't judicial misconduct. He was doing the best he could under the circumstances. So now I had one on the assigned counsel program, and I promptly forgot what it is. It's going to come to me in a minute. Assigned counsel. I've completely drawn a blank on it. Anyway, doesn't matter. The point was, senior moment, thank you. This was one of the problems. So each one of these counties had a different program, but there was another issue that made New York unique, I think, among the states, and that was that it maintained, right from the colonial period, a town and village court system. There was some, I believe, 2,700 town and village judges. And of these, the majority, by far, are not lawyers. They have no essential legal training other than a few weekend sessions. And so they operate in a system almost completely independent from the regular court system. They handle over half of the cases in New York State, but we don't know how much they do because they actually don't report to anybody. They are really, truly independent. Some of them are paid a few $100s a year to maintain a court system with no clerk, no other help. And there are all sorts of bizarre stories about arraignments conducted in chicken houses or in people's kitchens, and they are a very strong, determined lot. Because they operate so completely outside the court system, and it is almost impossible to set up any kind of a uniform system of justice because public defense has to cater to these town and village courts. And if you have a single part-time public defender, you have a small staff of public defenders, how do you run around every night trying to cover all of these various courts? You can't. And so what tends to happen over and over again, I was sitting up in a court up in upstate New York, and the people would appear before the judge, and the judge would say, I just got an email from your lawyer. You haven't met the lawyer, you've never met him, but you actually have an assigned lawyer, and he talked to the district attorney today, and this is what he recommends that you plead guilty to. And the person would go, what? Who is this guy? I've never heard of him before. And they say, well, it's your assigned lawyer. He's talked to the DA. This is what he's recommending. What do you want? You want to go back to jail, or you want next week? We'll do the same thing again. So that is not uncommon. That's a quite typical situation. I do remember this other assigned counsel case. I will just tell it to you because it's a kind of a cute case. One county set up a system in which they would have assigned counsel, and everybody in the bar association would agree to take cases. So every lawyer that practiced in that county was a member of that bar association and would agree to take cases on an assigned basis. And that went along fine for years. All the lawyers were happy because they were all getting a slice of the pie. They were all getting a little bit of this assigned counsel work. And one day, a lawyer came in from out of town. He was from another state, and he did property work. And he'd been there in the county for a couple of weeks, and he was assigned a felony case, an assault. And he went to the judge and he says, Judge, I've never been in a courtroom in my life. I know not one thing about criminal law. I can't possibly do this case. And the judge says, well, I don't know. I got a plan here. What am I supposed to do? You've got to take the case. He says, Judge, I cannot take the case. I am truly incompetent in every meaning of the word. And the judge said, well, in that case, I'm going to fine you $1,000 for contempt of court. So he fined the judge, the lawyer, $1,000 for contempt of court, and the lawyer said, fine, all right, if that's what I have to do to get out of this thing, I'll pay it. He paid the fine, stalked out of court, and 2 weeks later he got another assignment. And so that's what generated the complaint to the commission. And so I raise that only to show that from the judge's point of view, he's saying, what can I do? This is the plan that was filed. It has nothing to do with quality. And being cynical, the judge is also saying, oh, come on, how hard is this? All of these cases are decided by a plea of guilty. All you have to do is go talk to the district attorney, tell the defendant what he's going to plead guilty to, and that's what you have to do. How can that be so difficult? So I just throw that one out just because I hadn't remembered again. In any event, as I was leaving the commission after this period of time, I had a case in Troy which kind of changed my life a bit, I think. I had been used to a lot of odd cases involving public defense, but this was the oddest one I'd ever encountered. This was in the Troy City Court, and Henry Bauer was the judge down there. And he had developed a clever system. He perceived that a number of people who appeared before him were obviously guilty. They were going to get it right from the start. So it would be far better for them and for everyone else if they simply went to jail right away. Then they would eventually, when they served enough time, he would bring them back and allow them to plead guilty, and they could go on their way. So he did this by imposing very large bails, $20,000, $30,000 bails. The one I particularly remember, he imposed a $20,000 bail on somebody who was supposed to have ridden his bicycle on the sidewalk. He was doing this routinely for things like simple trespass, or for sitting on a stoop, or for simple marijuana. Marijuana in New York, of course, as you know, you can't has no jail sentence for the first offense for simple marijuana. But he would impose a $30,000 bail, have the person go off to jail for a couple of weeks, waiting trial, and then would eventually bring them back and plead them guilty. And the key was, of course, he wouldn't appoint any lawyers. The system wouldn't have worked otherwise. And these people were, let's say, the poor or the disadvantaged, the people that you don't necessarily, if you were a business person, want them walking around in town. It seemed to have been part of a general effort to cleanse the town of undesirable elements. Now, the thing that I found odd about this case was that there was, at the time, a very distinguished, or at least they believed they were distinguished, public defense system in Troy. They had a very good public defender, they had a very energetic office, and these two systems of justice went parallel with each other. The public defender's office was in court. They saw these bails being set, they saw these people coming back without lawyers, they saw them being sentenced to jail when they couldn't even legally be sentenced to jail, and they said nothing for years. We finally found it out by some inmate who wrote to us and explained the situation and said hundreds of other people were in the same situation. And it was true. And eventually Judge Bauer was removed. A lovely guy, by the way. Every time I see him, he comes over and he hugs me and asks about my family. He's just a wonderfully friendly, nice guy. And everybody loved him, and the public defender even came to the trial and said what a wonderful guy he was. But anyway, after I left the commission, I decided I just did not understand how this could happen in New York State. So I went to NYSDA over there and asked that they take me on for a volunteer for a year to see if I could figure out why this was going on. And after being at NYSDA for a year, I was getting frustrated, and I voiced my frustrations, and they said, you know, you really ought to go somewhere else. Why don't you go to the Civil Liberties Union? Maybe you can do something over there. So I went over to the Civil Liberties Union, and one of the first things we started to do was to work on some sort of a lawsuit that would correct this nonsensical situation. And so I went around. It was a simple thing to do. You go to any jail and you would find plaintiffs, people there that shouldn't be in jail, that should be out, that hadn't seen a lawyer, hadn't talked to a lawyer. I remember going one time down to Schenectady County to what was called the cattle call. And you would go down there, and as court was about to start, they would say, everybody who's looking for a lawyer, public defender, come out in the hall. So we'd all troop out into the hall and stand there, and the public defender, right in front of everybody else, would say, call the names, and then explain to the people what they were going to plead guilty to. And that was sort of the way it was. And I remember several people saying, yeah, but what about this? And they said, look, that's the plea. You want it or you don't want it, you know. And then you went back into court, and they would bring people out from the jails. And I remember you could sit there and you'd watch as the lawyer would introduce himself to his client while he was standing there before the judge. Obviously, they'd never met before. The person didn't even know who he was. So without any consultation at all, they would just announce what the person was going to plead guilty to. And I remember there was one guy that said, I don't want to plead guilty to that. And the judge looked at it and he said, well, you were here 2 weeks ago, and it said that it was going to be adjourned so you could talk to your lawyer. And the guy says, yeah, I was given a name, and I called, and I kept calling and calling, and his mailbox was full, and he never answered, and I've just never been able to get in touch with him. And so the judge says, all right, we'll adjourn it 2 more weeks so you can talk to your lawyer. And the guy looks over at his lawyer, and he looks at the judge, and it suddenly dawns on him he will be back 2 weeks later, never having talked to his lawyer, and he will continue to sit in jail until he decides to plead guilty. And so, oh, okay, maybe I better plead guilty. And that was the way out. Anyway, that sort of situation was very typical, and that was part of that's why it was so easy to find plaintiffs for this lawsuit. Now, my idea at the time was I wanted to do a lawsuit in which I felt the real victims here were the counties. This was an unfunded mandate that had been put on them, and they ought to be suing the state to try to get adequate funding so they could set up an adequate program. Eventually, after it got talked out in higher circles, wiser heads prevailed down there, and they said, no, Downs, we don't like your theory. And so I went off and did some other things. And later, another group came along with the President Harrell Herring case, which basically says the problem is with New York State, and puts the whole blame on them right from the start for never having set up any kind of a system that adequately addresses the problems of indigent defense. And I think they were right. I understand why they took that approach. And I have to say, just quickly, before they did that, they went through 2 very long, serious studies of the problem in New York State. One was the Spangenberg report, and one was the Kay Commission. And both came up with a long list of problems, which I could, if anybody wants, I have a list, we can start to talk about them, but those are some of the problems we should probably be talking about. I just wanted to end at this point, and then we'll kind of get into some of the substances in New York, with a kind of an update of where we are with the case. The case, of course, was filed in 2007. The Court of Appeals upheld the basic theory in 2010 and sent it back to say you have to go to trial on this case. And the class was certified in 2011. So right now they're undergoing discovery, checking out all of the various discovery issues that are going on. And I just got word a couple of days ago from the CLU, they gave me a call, that discovery is coming to an end, and they are actually looking for more plaintiffs. This is the problem with the problem, not plaintiffs so much, but people who are suffering under a dysfunctional legal system. And part of the reason for that is that, of course, you start out with a group of plaintiffs who have gone to jail or done other sort of things without having a lawyer present, but all of those have somehow got their cases resolved, have moved on, and somehow you need to show that the problem has continued, that nothing has really changed, and so they want to be able to call these people at trial to say, it's the same problem all over again. You can go back to the jails any day and find a group of people that were never adequately represented. So it turns out Washington County is one of the plaintiffs in this lawsuit. Not Washington County, but the Washington County is one of the targets, one of the defendants in the lawsuit. And we are here in Washington County. And so I just wanted to encourage, if any of you know of people who are presently in jail or poorly represented, let me know, please. The Civil Liberties Union would love to interview them and maybe call them as witnesses when this thing actually goes to trial. So you can, that's one big thing you could do to be helpful right now.
I just want to add to that. Don't go too far. Because I know that the group here is larger than local. The other counties that are defendants in the lawsuit are Suffolk County. So anybody from Long Island, if you have access to folks who might be interested in telling their stories, Suffolk County, Schuyler County, Ontario County, and Onondaga County, which is Syracuse. So that call for if in your jail ministry, in your work, or as a family member, any way that you might know folks, please Steve would love, and the CLU would love to hear from you. I said I put the sheets on the table, so we don't have time, and we don't want to do all the talking, so I don't want to talk about all these issues as legal issues. You remember I said I remember the clients, not the issues. But one of the ones that I thought maybe we'd start out with is right under points to ponder, and that's the counsel at arraignment, or counsel at first appearance. And that's tied directly into the Harrell Herring case, because when the CLU brought the suit, of course, the state said, oh, no, this isn't a lawsuit. This is not something we can actually do in the courts. This is a legislative problem. So you need to go and build your mass movement and have it changed legislatively. And that challenge, the state saying, no, just dismiss the case because it really isn't a lawsuit that can be brought, went all the way up to the Court of Appeals, which is our highest court. And the Court of Appeals said, on some of these issues, you're correct. Not every issue that the CLU brought is justiciable. The judges really can't do anything about it. But they said there are some things where it's clear that the system, if we believe what's in the pleadings, which is what we have to believe to decide whether to just dismiss the case outright or not, one of the things that it says is that people are not getting arraignment, getting counsel when they're first brought in before a court. And sometimes they're not getting counsel, as Steve was telling you, for weeks, days or weeks. And that denial, outright denial of counsel, is something that is a legal theory that the courts can look at. That opinion in Harrell Herring in the Court of Appeals was written by Chief Judge Jonathan Lippman. And he also heads up something called the Indigent Legal Services Board. The Indigent Legal Services Board and the Office of Indigent Legal Services were created 2 years ago. They are not a statewide public defense system. They are not an independent public defense commission, which are things that my office and many others think are what we need to fix this problem. But they're an effort to make the counties accountable for how they spend what little state money goes out to the counties. And because Chief Judge Lippman is the chief judge of the state, and right now it's Jonathan Lippman, is the permanent head of the Board of Indigent Legal Services, and he's the chief judge. So he said, after Harrell Herring came out, he said, we're going to make getting counsel at first appearance a major issue for how the Board of Indigent Legal Services hands out its money. So there are some efforts in some counties to figure out what could we do to set up something that we could get some state money for to fix this problem. If not countywide, at least maybe in one court, maybe in our city court, maybe in something. And I'm saying that because it's the flip side of saying the lawsuits will not make the difference. The lawsuits can open doors. This lawsuit has already had that impact. And so any of you who are in a situation where you know of people who are not getting counsel arraignment regularly in a village court, a town court, a city court, or any other court, it's something you can raise locally. Talk to your public defender. If you don't have a public defender, talk to the Legal Aid Society or the head of the Signed Counsel Program, people in your bar association, or just raise the issue. Somebody mentioned letters to the editor, letters to your local legislator. Ask questions, and with that, unless Steve has something else to add, and he does, then we're going to invite you to ask some questions and see where we go from there.
I just want to mention that the town and village court system, as I indicated, disposes of about half or more than half of the cases. But these are not courts of record. They are courts not of record. And so, and they also have a system of midnight arraignments. That is to say, when the cops pick up somebody, they can't take them directly over to a county, to a lockup facility. They need a judge's order to do that. And so they will literally wake up a farmer or a gas station attendant or whoever it is that is the judge in that town and have them come down at 2, 3, 4 o'clock in the morning and hold court at an arraignment. And that they set bail and they'll take the driver's license and they'll do a bunch of other things and then they go off to the county jail. And in a lot of places, the way the courts use this is to say a lot of the defense folks do is to go around, they have an investigator go by through the jails once a week and find out how many people have accumulated over the weeks that have been sent there on these midnight arraignments, because of course no defense counsel is there, no prosecutor was there. So that's how the system sort of presently works. The Office of Court Administration, I used to have lots of conversations with them about this, and they would say, well, the law says that everybody has to have a lawyer at the arraignment. That's one of the critical periods when you really, really need a lawyer. So that happens in New York State. And I'm saying you're delusional. 80% of all arraignments in New York occur without any lawyer within 100 miles. That just doesn't happen. And they say, no, that's not true. It happens, absolutely. And I say, walk down the street, go walk 6 blocks down to the Albany City Court. It takes 2 weeks to get a lawyer after arraignment. And they say, no, that's not possible. It doesn't happen. And I say, yes, it does happen. Go down and walk down. And they still haven't walked down. There is a large amount of denial in the court system about the dysfunction that goes on. And part of the reason is because of the town and village court system. This is the tail that wags the dog. It is a system so ungovernable. And I don't mean to criticize it. That is to say, the one consistent thing about the town and village courts is the inconsistency in them. There's no statement you can make about the town and village court system that is not immediately contradicted by something else that is going on. And so the regular Office of Court Administration simply doesn't want to deal with them, and they don't. They don't try to regulate them, they don't take statistics from them, they don't know the number of cases they're resolving, and they're only slowly beginning to understand that they have to do something about the arraignment problem, and it's just coming very slowly, and it's part of this dialogue that the lawsuit has set off, I think, about how much voice do we really want to give to the people that are getting arrested. How important is that to us? Right now, all of this is being funded by the counties. And if you're a county legislature, you're faced with this dilemma. Should I spend this money that we don't have and will have to raise property taxes for to fund schools or roads? Or should we use it to hire lawyers to defend people we don't like in the first place? Which should we do? This is such a difficult problem. And so you can imagine how this goes. And part of that is, should we hire lawyers to voice the discontent of people that we don't want to hear? And I think if you phrase it in that terms, you will see why this is going to be a very long, protracted debate. And as Marty has suggested, it will only really be solved with some sort of a mass movement of people that says we are willing to listen to these voices. We want them heard. We don't want them silenced anymore. Oh.
So the magic word there being listen. We've been doing talking. You've been very patient and listening. Sheila, how long do we have left?
We have until 10 to 1. It's now 10 after 12.
Okay, we should be able to have a conversation here. Has anybody looked at the sheet and have a question about any of the issues? We'll kind of start formally and then we'll move on. Yes?
I have a question about this issue with the village and town judges. How is it that we allow this? I mean, and I don't know the answer to this or even the theory behind it, but we have state police and county sheriffs making most of the arrests on the highway, at least, you know, after 10 o'clock at night. And then they bring them to the town or village judge wherever they were patrolling, I suppose. Why is it that the state allows the state police to make the arrest, but then the arraignment goes to a village or town court? Why wouldn't there be a requirement that if it was a state police arrest, it would go to some other higher level court for an arraignment?
That's a great question, and I'm going to consolidate it into something that fits my purposes, of course, and that is, why do we have state systems for the state police? We have state prison system. We have county prosecutors. We have county public defenders. We have a state judicial system. And I didn't let Steve take this first because I want to give you the out-of-staters perspective. I've only been in New York State since 1996, so I'm still a little boggled by the whole thing. There was a New York Times series a few years ago on the town and village courts. William Glaberson, I think, was the reporter. You can Google it. And on that sheet, there's some citations to the NYSDA website, my office, and somewhere on there, I believe, we've been redoing our website, so I can't be sure, but I believe that there's still a link to that. If not, I'm going to have cards afterwards, and you can call me. The OCA actually did respond after that came up, and they did a report, and they tried to fix some things with the town and village courts. I believe the answer to that question is turf. Turf is a four-letter word. Towns and villages make a certain amount of money off the fines that are collected in their town and village courts. I know someone from out of state who came in to do an evaluation, was part of the studies that Steve was talking about, and he was boggled by all of this. But one of the things I remember him saying to me, Marty, I went into this court and they pulled a box out from under the desk and they were putting money in it from the fines. They were just putting the money and then they were putting the box back under the... All the injustices to the defendants who didn't have lawyers and the sort of chaotic procedures he was dealing with, but the fact that there was this money just floating around, and sometimes the Commission on Judicial Conduct, and I'll let Steve address that, would find this was the problem. Not necessarily that people were stealing it, but simply they weren't dealing with it procedurally. I think turf is really the answer. Villages and towns, the magistrates have local power. They want to keep it, and they turn it on clients and say, you know, you're actually better off, because if you have a lawyer here, then we'll take that into account. But because you don't have a lawyer, we're actually kind of cutting you some slack. So there are all kinds of arguments come in, and that's why locally it has to be raised, I think, locally. Steve, you want to address that more?
There is an interesting money dance that goes on throughout this. And this will come up in a discussion of judicial independence. A lot of the, how to put it, a lot of the difficulty that goes on is with the funding of public defense, as I've indicated. And a lot of judges will take this into account. They will say, if you hire a lawyer, you've already kind of been fined. And if you get a public defense lawyer, you're already costing us money. If you can work it out before you do that, then you don't. And for example, don't have to worry about this. And for example, if you plead guilty to a local violation, let's say you get a state violation, and you plead guilty to that state violation, the money goes to the state. What good does that do us? If we offered you a deal where you get to plead guilty to a local violation, we don't have to appoint you a lawyer, because you don't need one for that, and we get to keep the money. So there's a lot of this kind of trade-off that goes on, and if we change the system now, because the town and village courts handle such an enormous number of cases, if all of the state court cases went to the state or to the county courts, it would really overload, it would burden the county courts, which deal supposedly with a higher level felonies. And so the practice has always been to keep the felonies in the town and village courts until they're indicted. Once they're indicted, they go up to the county court. But as long as they're kept in the towns, in the town and villages, then you can manipulate them down there. You can kind of weed out the people that you don't want to hear, that you want to get whacked, that you want to send away. Let them go up, and the ones, the good old boys that you don't want to have bad things happen to, can get taken care of quietly in a local court and may not even get reported to OCA, and you may not even have a record. I mean, it's really hard to say. I think there's a lot of that kind of, we want to keep control of the process, we want to keep control of the money, we want to be able to say who really is going to be prosecuted and who really isn't. Yeah.
This is about seems to me that you're talking about need for research as well. I mean, like when you're asking for the arraignment issue and how many lawyers, how many people, when they're arraigned, have a lawyer, isn't that something that a survey could be done, whether done on, like I know in Schenectady, where I'm from, the League of Women Voters and the Fund for Modern Courts have had court watchers that have kept track of things. I'm not sure they kept track of whether there was a lawyer at arraignment. Those are generally in the big courts, the city courts, the police courts. But couldn't there also be simply asking for information on whether, asking, for example, the public defender's office, do you provide arraignment, do you provide an attorney at arraignment? And asking them, do they? Just to get that kind of information. And the other thing is, I mean, I'm not sure what kind of activity the SUNY Albany takes in this, but they've got the, you know, they're one of the criminal justice schools. They're the one that put out the statistics nationally. They seem to be more academic than being involved in sort of practical stuff. But, you know, in other words, looking at that issue to trying to determine how many people are there and getting some idea about it. You understand what I'm saying?
And thank you, Jim. That's a terrific lead into something I wanted to say, and I'd kind of forgotten before. Your group in Schenectady did a fabulous job, and as a result of that, it put so much pressure on the local authorities that they actually went and changed the system. They actually...
I was a legislator at the time.
Were you? Well, then you deserve even more credit. I want to say that Schenectady, I believe, has turned itself around and now actually makes visits to the jail and talks to the clients before they appear and so on. They've done good. And I wanted to mention, I felt bad that I'd sort of trashed Schenectady without pointing out that the kind of citizen involvement that Jim is talking about here is effective, particularly on the local level. And it's something worth considering. It's hard to mobilize this for 62 separate counties with all sorts of separate defenses, but local people in local communities can make a tremendous difference, and Schenectady is a great example of that. But it's also an example of how difficult it is to get accurate statistics on this stuff. I think we've had a number of people all the way from Spangenberg to the K Commission to certainly the Commission on Judicial Conduct that at one time or another has tried to do that and simply realized that the system is so decentralized that it is really hard to get accurate statistics on it. That's all I can really say.
I can add a bit to that. The office that I was talking about before, the Office of Indigent Legal Services, one of their charges is to study the problem, but not just to study it, make recommendations. Unsurprisingly, creation of the office has moved at a pace about like this. Legislation creating it was passed in 2010 before the legislature went home. I think that was around June. The board was constituted. That's an appointment system that's intended to make it somewhat independent. The governor makes the appointments, but they're on recommendations from various entities, including the Association of Counties, because they have a fiscal interest as well as a local interest in that. Some other entities, State Bar Association and so on. They met on November 1st, 2010. An executive director was selected and put into place in February of 2011. And that executive director was able to hire counsel for the office by May of 2011. By the end of 2011, I believe they were up to 5. They're supposed to be an office of 10 people. I believe by the end of 2011 they were up to 5. And they are in the last bits of hiring for a full complement of 10 people to do many things statewide. But data is one of them, and I know that they are having conversations. One of the people that they hired is a data research person, Andy Davies, who used to work at my office for a while, so I know that they have good people doing this. It's going to be difficult. The Office of Court Administration has for years collected something called UCS 195s, and that's information about public defense. And you can read through them for any given year, and when you get done, you really don't know much more than when you started, except that nobody keeps the data the same way. Some people don't keep data at all. So it's a mess. It's a question that's being addressed. I I don't know if they're talking to the University at Albany. I do know that there was a meeting not too many weeks ago, maybe Barbara Spring can remind me. There's an effort in the School of Criminal Justice to create a multiculturalism in the justice system in the 21st century, or something similar to that. And I don't know where that's going. I don't know if these will be questions that they might address. But again, anybody with a connection to the University at Albany or to anywhere else, these are questions to ask. Just asking these questions, asking them publicly, asking them of your local officials, that's great. Anybody got... oh, sure.
I mean, I know that both the League of Women Voters and the Fund for Modern Courts have developed a way of doing the court monitoring. So it's not like you have to reinvent the wheel. They've done that kind of stuff, and it can be replicated. The League of Women Voters has had a real interest in criminal justice issues. And so I think, you know, that kind of a volunteer group can even goad this indigent crowd that you're talking about, or at least help them. So I think there's a lot of opportunity for doing stuff that comes from the local rather than from sort of a funded basis.
I'm so glad that you gave the pitch twice for the League, because I heard it the first time and let it go by. If you, again, you look on the sheet there on on the website of my office, one of the things that we did in 1998 and I think into 99, we held fact-finding hearings in New York State in 4 locations, and the League of Women Voters of New York State and of some of the locations sponsored those. You're absolutely correct. They're great, active in this area, the Fund for Modern Courts. Again, if you have an in with those groups and suggest it, and feel free to write to the Office of Indigent Legal Services. They don't have a website yet. They're working on it. They have somebody now hired that's working on a website. But you know, make suggestions. How can we ask questions? How can we be helpful to you? Steve, did you want to add anything to that? Right, Joyce?
I just want to say that project at SUNY on multiculturalism, we invited them to be on the panel. They couldn't do it because students were just arriving, but they put the conference agenda on their website.
Oh, that's true.
Yeah,
You're talking about this conference was put on this multiculturalism
Right. So
institute
we're
at
very
SUNY. That's terrific. I hope that we can keep up that kind of contact. Yes, ma'am. Mary.
We all have different pieces, all different pieces, parts of a puzzle. What you suggested of statistics, do you have it on your website of specific information that's helpful to you that we can actually record?
I'm not a data person. I'm one of those people that went to law school because numbers scared me. So I'm not the person at my office that can give you a really good answer about that. But if you give me a call, as I said, I'll hand out my cards afterwards. We can talk more about what specific things there are. I'll take a look at your county. For instance, we have some of the UCS 195s that OCA collects. And I can have a conversation with the data person in my office and possibly even schedule something with the ILS office if they're interested. So some of this is going to be a lot of networking. And I'm sorry, that's...
No,
Steve,
I
got me?
had another question, too. Are you involved working with the Center for Court Innovation?
Blanken is, yeah. I know somebody who used to work there, or did. I and my office don't do a lot of direct work with the Center for Court Innovation, she was asking. They do a lot of data research. They're into technology, how to gear things up so information can be collected and other good things can be done. I have not worked with them directly on these issues, but that's a good suggestion.
Yeah, they just put in with no fanfare or announcement, they just put in adolescent diversion court in Syracuse, and they just did a pilot program that they've installed in Brooklyn, I believe, where they're using restorative justice model, Native American restorative justice model.
Right.
And with my particular area, we see the incarcerated while they're in jail, before most times when before they get in front of a judge.
Yeah.
I think probably, and we're from Onondaga County, probably you have heard more than one or two things that they never see their lawyer. But we are in a unique position, but we're also in a fragile position to keep the relationship we have going. In our particular case, we're jail ministry, and as jail ministers, we're given 40 passes for visitor advocates to go into the jail. We've collected all sorts of data from people saying all different sorts of horrendous things that are going on. But for the longest time, we didn't know how to funnel that.
Right, and I think that's the idea that a local group that's doing jail ministry, doing other work, and has data, whether it's anecdotal data or hard numbers, that information, well, what do you do with it? And I think to have conversations with my office, for example, the CLU, if it happens to be one of the 5 counties that's part of the lawsuit, to see if that's something that they would be interested in, and the Office of Indigent Legal Services, if that was something. But again, also, you know, the idea that you can use that locally. It's really good to have conversations with statewide entities, and when there's a lawsuit, like the CLU lawsuit, to make sure that you don't do something locally that kind of interferes with something. So I'm really glad that you asked the question. We have this information, what should we do with it? And I think that like the town and village courts, like the public defense system, it's going to depend on where you are. And I would love to continue that conversation further, and I hope that your question has sparked other questions. Steve, did you want to add anything to that? I know there were hands back there. I hope I didn't talk too long. Wait.
My question is about undocumented persons, and I was wondering if in some of this issue that you were just talking about, how underrepresentation for them, if there's help in your offices for them.
What a terrific question. What about people who are here, who are foreign nationals, people who do not hold U.S. citizenship? What's happening with their representation? That's an excellent question. Like all of the other questions, the answer is to some extent it depends on the county. This is an issue that the Office of Indigent Legal Services has allowed grants to be written for, and so some of the state money that's going out is for that purpose, to help bolster that. There's a feeling that it's less of a problem in New York City because there are so many immigrant advocate organizations there, and a lot of the public defense offices in New York City have somebody in their office who has immigration law experience. For those of you who haven't come face to face with this problem, when the entirely complicated federal immigration law crashes into the completely unbelievably complicated state or federal criminal law system, and they hit together a lot. Hey, I'm your lawyer. I got you a great deal. You will not do any jail time at all. Isn't that wonderful? What do you mean ICE is taking you away? If you plead somebody to the wrong thing, or even if they don't plead to a drug charge but they make admissions, I couldn't have had the intent to do what they say I did because I was high on drugs at the time. There's a possibility that that admission about drugs could get you deported. So it's really important that lawyers doing the criminal law know enough about immigration law to get in touch with an immigration lawyer if they can't figure out the answer to the question, what happens? And I don't want to hog the mic, but one other thing I want to say about immigration law is that the U.S. Supreme Court, which has not in recent decades been quite as friendly to making good law for criminal defense as we would necessarily like, came out with a case called Padilla versus Kentucky, sorry, wrong state, that said criminal defense lawyers have a duty. It's ineffective assistance of counsel to give bad advice and to not advise a client who is in danger of immigration consequences about those consequences before you plead them guilty. That's a huge step. And so, again, if you're in a location where you know that you have a population of people who are not citizens, and this is true for green card holders the same as it is for people who do not have documents, who are out of status, a criminal record can get you out of here. You came here at 6, you don't remember a thing about the country of origin, you've pled guilty to a drug felony, and you're going to get acquainted with that country because you're out of here. So it's a huge problem. It is being somewhat addressed. Much more could be done. and it should be raised locally. Steve, you want to come up and add and then ask for the next question?
Yeah. We've had a number of cases, for example, where someone was picked up on an immigration violation, an undocumented violation of some sort. Often, one case actually happened, the person was stopped at a stop sign and was picked up by the police because the police thought he was somebody else. But while he was there, they happened to ask a few questions, found out that he was undocumented, and, he vanished. And this was in Albany, and we sort of assumed that we could get counsel for him and do the things that had to be done for him and get him on his way, hopefully, get him out. And the next thing we knew, he discovered that he'd been sent to Texas. And this is the kind of games that the feds play. They will take people and they will move them to places where there aren't lawyers available, readily available. And most of these cases are frankly resolved without lawyers. And if you get lawyers, they oftentimes will sort of give in and allow the person out because they figure they can get rid of 80% of the people without lawyers. This particular place in Texas, as I recall, we were trying to get a lawyer for him and trying to find somebody who was willing to go way out into the boonies where this prison was in Texas to represent him on a case that occurred in New York. Now, these are the kind of games that the federal government is playing right now, that they're, in my view, are being completely unfair about it. But it also raises or strikes up the kind of discussion. We're talking about county defense projects, county defense plans. We don't even have a state plan in New York. So when somebody is whisked off to Batavia, there's no state response to that. It's the legal aid clinic in Batavia that has to deal with it. And when it goes down to Texas, it's the same thing. There's no organized, coordinated response on the defense side to what the federal government is doing. So already you can see the problem here, the disproportion of resources, the disproportion of response to what the federal government is able to do. And as more and more of this becomes federalized, as more and more things become terrorists, terrorism is everywhere, and it's undefined, so it can mean almost anything. You're going to see more and more of this federal takeover and moving things around, and the defense is just going to be behind. Oh, next question. Yes.
On the technology tip, first of all, thank you very much. I enjoyed every single bit of information that you shared. I learned a lot.
Good.
And I appreciate it. On the technology tip, it seems like the court system is in the ancient Stone Age in terms of technology. I just wanted to know if you had any information regarding the developments in terms of technology, what the courts are doing. Because really, why does a public defender have to be present? I mean, there's this thing called Skype,
right.
And there's multiple different platforms that people can use to be there without being there.
Yeah, Marty can probably speak to that better, but I will just mention, yeah, Skype is one of the things that is being tried. I remember way back, and this is 20 years ago, the town and village courts, of course, are courts not of record. They don't have anybody there except the judge, and oftentimes they do trials that have no record at all as to what happened other than the judge's recollection. We said, wouldn't it be great if they could at least have a tape recorder? How about just a tape recorder? Well, it's 20 years down the road and they're still debating it. Could we do this? How could we do this? How could we get them to have a tape recorder? I mean, who would pay for it? Who would run it? I mean, it raises so many complications, the court just can't deal with it. If you can't do that, I have relatively little hope of a lot of brilliant technological innovation, but Marty's going to prove me wrong here.
Oh, no, I'm not going to prove him wrong, and I do see hands, and I hope they're in response to this, and we'll get to you. Two quick points about that. One, actually three. To go to Steve's first, the Office of Court Administration did, after the Glaberson articles, they did say, we're going to put recording devices in every one of these courts. I don't know if they got them in all, but they did put them in some. But then your point about the technology kicked back in, and so if you go and say, I would like to get the recording for this case, they want you in some places to know the name, the date, and maybe the time that it was heard, so that can all be difficult. Storage is a problem, and public defense is not availing itself of doing that. So they are working on that a little bit, but not too much. Skype and video conferencing for visits between a client and a lawyer are very, very problematic for those of us who believe that in order to represent somebody, which the word represent, I am representing you. If I represent you, I am representing you to the court or to the probation officer, whatever. It's very hard to do that if we don't have trust. And it's particularly hard to have trust between a public defense lawyer and a client when the client has already heard all these stories. If they didn't know, if it's their first arrest and they didn't hear them before they went in, if they've been in jail very long, they've heard all the stories. So not only do they know they haven't seen their lawyer, but they've heard of the people who haven't heard or seen their lawyer in days or weeks. Okay, then I walk in and say, hi, I'm Mardi Crawford, I'm your lawyer, and here's the offer from the prosecutor. That's because, see, if I did trials, which I don't, but if I did that, I'd be being a good one because I'm introducing myself first and then telling them the plea offer as opposed to saying, hi, the plea offer is. So we're very resistant to having technology be the way to meet the clients. And the other thing is we're very suspicious because jails, as the U.S. Supreme Court said in another context very recently, jails are dangerous places. And they didn't suggest that we fix that. They just said that justifies strip searching anybody you're going to put in general population. But there's a U.S. Supreme Court case that says jails are very dangerous places. So we as lawyers who have a duty to speak with our clients and maintain confidentiality, am I really sure that nobody's listening in to my Skype conversation? They promised me, they put that computer in a room and they're not recording it, they're not listening. Do I really believe that in every jail in the state? Maybe not. So that's a problem. For things like adjourning a case, just explaining to your client, you're not coming to court today after all, it's been adjourned, don't say anything to me about the case over the Skype. You know, there are ways to deal with that. And so now I'm going on too long. Did I answer somewhat of your question? Okay, and if you want to have more conversation, I'd love to talk more about this. Were there other responses to that issue? I saw some hands go up. Yes?
I was just going to say that if you believe that they don't listen to or record or pay attention to what you're saying on those Skype conversations or the so-called private attorney-client telephone lines, Al Sharpton has a bridge he wants to sell you.
Yes, I think that believing that those are confidential is being would be being overly trusting.
I'm sort of an outlier because I don't practice in New York, I practice in Connecticut. And we had a similar system from colonial times in Connecticut for town, and we didn't have villages, but we had town courts and city courts. And the reason they were so popular, I can talk about Connecticut, and I suspect it's equally true here in New York. The reason they were so popular was not just a question of turf and power for the local gas station attendant who was elected judge, but it was a very convenient way for the people who control the town, the wealthy, the power elite, if you want to call them. I hate using those words, but whatever you want to call them, to keep their kids out of trouble. When little Johnny raced down the street and ran over the nun, a dad could somehow fix it up and the town judge would really slap him hard and he'd probably pay a $50 fine and pay for the funeral. And if you were not from that part of town, if you were from the other side of the tracks or you were a minority, particularly when nobody wanted minorities in their clean white little town, and that was true in Connecticut also, what happened was you were able to send them to the town court, or in your case, the county courts, where they could be effectively dealt with and removed from the community based on color or lack of economic connection or political connection. We had a very funny thing happen in Connecticut. In the late 50s or mid-50s, we had a governor named Abraham Ribicoff. And John Bailey was the Democratic state chairman at that time. He later became the national chairman of the Democratic Party in the Kennedy administration. But they did a study, because this was before Reynolds versus Sims and those one-man, one-vote cases were decided. And so what happened was they did a study in Connecticut because they didn't know what to put in the Democratic platform, since we're in platform week right now. And so they did a study to see what would happen in the next election because Rivercroft was so popular. And their studies showed them that they were going to win both houses of the legislature. They were going to take not only the House that there were 169 towns in Connecticut, and every one of them had a legislator in that legislature, and then we had one that was done on the popular vote basis, modeled on the federal Constitution. And so the question was, did we have any chance of the Democrats taking over the part of the legislature which was controlled by all the little Republican towns that didn't want to vote for any benefits for anybody that lived in a city? And their statistics showed they were absolutely going to win both houses of the legislature. And nobody believes them. They didn't believe their own statistics. So they put in their Democratic platform that they were going to revise the town court systems in Connecticut, and they were going to create a unified court system for the state of Connecticut, which absolutely nobody in the Democratic Party was interested in doing, but it was a modern, progressive, cool thing to do. And they won the election, and they took both houses in the legislature. And then they were stuck with their pledge. So they had to abolish all the town courts, where all the corruption took place and where all the local car dealers could get their kids out of trouble without having a record. And they created, in those days, what was called the circuit court, which was a uniform state court. Everything's recorded, everything's on the record, everything's reported, everything's statistically controlled. And then subsequently in 1978, they merged that court with the Superior Court. So we have now a one uniform court system in Connecticut. And the advantage of that is that everything's done on the record. You have a centralized location where the public defender doesn't have to drive to 60 places to cover the dockets. And the sad part is that for people like me who made money and were successful, I can't get my kids out of trouble by juicing the town judge. So it's a dilemma for people who have money or who have had success on the one hand, but it works a lot better than having 2,700 bozos in non-reported judicial proceedings,
right,
running your court system. And I, even at this point in my life, after 45 years of doing this, am astonished when I drive, because I live in Ridgefield, Connecticut, and my house is 0.5 of a mile from the New York border. So when I wander across the line, because they don't care if you're a member of the New York Bar, and you show up with somebody, I'm always astonished. I'm just astonished at who's sitting in the chicken coop. Yeah. I remember one time I drove to some judge's house in Carmel, New York, who actually is a friend of mine, whose law partner is a friend of mine, actually. And I was in his kitchen having coffee, and his wife was fixing eggs, and we were doing an arraignment.
Yeah. And
what is this?
Right. If I can summarize and
right,
and sort of link it to one of the themes that Connecticut, maybe they didn't have a mass movement to get rid of the local courts, but there was a mass action of a statewide party, Democratic Party, that helped to change that system. So, local pressure, all politics being local, maybe we can take something from that. And also thank you for pointing out the connection between the local power and wanting to, if you get stopped on the thruway and you go to a local court, they know right away that you're not from around here. And if you're black or brown, well, then they're real sure you're not from around here, and it feeds that whole system. So I had a couple other hands up, and if we have time, I'll come back to you. Is that okay? I just don't want to keep people that were cut off too long. We have 3 minutes, so I'll try to come back to you. Before Joyce talks, is there anybody else that hasn't spoken? Because there's a step up, step back thing here. Anybody have a question? I know we're running out of time. Joyce, can you? Oh, yes, Reverend Lewis.
Because it's just like I know something about theology, but I know very little about the law. So I step into a town, and I step into this chicken coop, And I'm going to be one of the chickens soon. Because I don't know the language. Something's going to happen around that kitchen table, if I get to the table, that's not going to be good for me. You know, the question is, what does a person like myself do? How, you know, what can I do? How can I really get justice?
I think you do what you were calling on us all to do, which is speak up before you're the person who's stopped. And we all need to speak up before we or someone like Reverend Lewis are stopped. I think that's the short answer.
Can I make just one
yes,
quick
and then
reason?
do Joyce
Yeah, before we automatically trash the town and village court system, let me just say that 2/3 of the judges there are not lawyers. And part of the reason for the enduring love of this court is that a lot of people like to appear before non-lawyers. They don't like all the legal gobbledygook. They want just common sense justice. And I gotta say, some of the very best judges I ever met in my life were not lawyers. They had a sense of fairness, they had they could administer, and they were really great. I remember bringing somebody over from Senegal at one point. It was a friend of mine. We went down to Coxsackie to the local court down there, and it was run by a fertilizer salesman. And later we saw the Court of Appeals and all the appellate division and everything else. But as she was leaving, she said, you know, that was the most impressive thing I saw the entire time I was here, was that a court could be run with such fairness by a fertilizer salesman. Because if you can do that here in New York, we could do it in Senegal. So but think about it. You might get justice there because some places did. Yeah, you definitely have a...
First, I really want to thank you because I think this is a pioneering conference for upstate New York.
Absolutely.
Your presentation is most important. I'd like to go back to the technology question and have us think about the fact that this is not only in our name, but it's our money. Any system is paid for by taxpayers' money. In the economically challenged neighborhoods in our capital in Albany, New York, we have 850 vacant buildings. But on one of these streets, we built a Taj Mahal, and it's the family court building.
Mm-hmm.
People have no place to go, no community centers, but we put an enormous amount of money into that. There was a thing where judges were having fancy apartments done in Albany, and they had to cut the budget a little. So there's money going into this system, and it's for us to say if we need technology that would be in people's benefit, where is this budget going?
Mm-hmm.
Okay?
Yeah, I agree. Yeah.
Just a possible response to Joyce's question is that over the last 3 or 4 years, the State Controller's Office has begun tormenting local governments throughout the state with record keeping. They've standardized fiscal reporting. They even make elected officials keep timesheets. Is this not a potential source of the kind of information we were talking about earlier with finding out when these courts are in session, what they're doing, who's present, where the money is going that's being collected? Possibly that a lot of that information is at the Office of the State Controller, Division of Local Governments, as opposed to the Office of Court Administration.
Yeah. I spent an enormous amount of time going through the controller's reports because that was the only way I thought that I could reliably get information about the town and village courts. And I just have to report one little story. We had a judge in at one point because he hadn't deposited any fine money for some number of months, and he hadn't reported any cases, and he hadn't sent in his controller's reports. And we asked him why, and he said, look, if I'm a dairy farmer, and I've got 600 head of cows, and if you've got 600 head of cows mooing to be milked, and you've got your controller's reports that have to be sent in, which are you going to give priority to? And that's why what I think we should do for the village courts is hire actually clerks that could run the books, because it's an awful lot to ask of some one guy part-time getting $500 a year that he not only keeps the records and all the books and sends everything in, but also holds court. And I just don't think a lot of people are able to do that kind of work all by themselves.
Right. Okay. If we're going to have to wrap it up quickly, you had one other point you wanted to make?
I was just going to add, just going to comment further that even the system as it has been reformed in Connecticut has its little glitches. And funny little stories. I won't mention any names, but I was sitting some years ago with a Superior Court judge who was a friend of mine and was telling me about driving up Route 8 in Connecticut, up towards the Winston, Connecticut, above Waterbury, and the road's basically empty at 12 or 12:30 or 1 o'clock at night. And he was driving about 95 miles an hour when a state cop caught up with him and pulled him over and started writing a ticket. And he said, "I'm required by the chief court administrator to give you this." And he handed him his judicial appointment card. And the cop said, "Oh, crap, now I'm going to have to stop somebody else." And he stopped writing the ticket. And I said, "Do you know the genesis of this policy?" And he said, "Yes." And it's a great story. Another Superior Court judge, or maybe he was a circuit court judge then, had been stopped for drunk driving in Westport, Connecticut, and went to court and promptly pled guilty to drunk driving, because he was. And we had mandatory 1-year suspension, and the sitting judge was trying to figure out why he was pleading guilty, and he said, "I'm guilty, I was drunk, I was not having fun." So he was found guilty, and he DMV suspended his license. And the next morning, when he got up to go to court, he called the state police and ordered a state police trooper to drive him to court. And then the state police trooper was ordered to take him to lunch and then to drive him home. And for an entire year, this judge had a chauffeur at the state police expense. And the story was, I was told anyway, that the agreement made was that they really wouldn't arrest judges so that they could avoid having to provide chauffeur services for them while they were sitting. And I always thought, and the final comment of this judge to me was, it's the only time in my life, Mark Gordon Hand said when they said he didn't have to pay income taxes, he said, the only time in my life I felt like a communist. He said, I felt like I belonged to the party.
Thank you all.